Tendencias regulatorias de la IA en el derecho comparado, enfoque basado en riesgos y otros. Begoña González, Senior Research Fellow del Max Planck for Innovation and Competition, España. Ricardo Fischer, tesorero de ASIPI, Estados Unidos. Moderador, Juan Felipe Porta, socio a cargo del área de PI de LUSSICH y Asociados Abogados, Argentina.
Bueno, bienvenidos a todos a...
Welcome everyone to this first panel. We have Begoña online. Begoña, can you hear us? Okay. Can we? Oh yeah, you're there. Oh yeah, we can see you now. And this panel, as you know, we're going to talk about the regulatory aspects of artificial intelligence. And we started talking about it with Ricardo and Begoña. We talk about different questions, and without further introduction, I'm going to go straight to the beginning of this conversation. So the first question that we're making or we're putting on the table when we started talking about this topic is, what are we regulating when we talk about regulating artificial intelligence, and is it needed, or can it be something premature if we do it? So I would love to hear Begonia, and I would love to hear what you think about these two things. What do you understand about regulation when we talk about artificial intelligence? If there is an agreement on if it's needed, or are there risks of a premature regulation? Okay, to answer your question, I would like to support my argument in something that's more visual. A couple of slides that I have that I would like to share. It's gonna be easier to understand. Can you see them now? Yes. Perfect. About the first question, what do we understand? Artificial intelligence has been with us for over 50 years. Something that we're talking about, and I believe you've mentioned it before, is that the boom of the language models like ChatGPT from OpenAI when it launched in November 2022. It was like a big shock for everyone, especially those who didn't follow this before. Artificial intelligence, as you see, is different techniques. And then it's computer systems that work from one way or another. And we don't have a definition, a clear definition of what it is, because even the term is by the scientist McCarthy in the 50s, in a way that they were trying to look for a technical system, a technology built by human beings that imitates the intelligence of the human being. And we're still far from that. We do have a lot of science fiction movies like Terminator, and all of them are very, like Blade Runner, they're very pessimist. But these are systems that have been with us for a while. If you think about Pac-Man, I believe many of you played it. I remember about it and I still play it. Pac-Man is based on a system of artificial intelligence. The little ghost that it's chasing things, it's artificial intelligence. So also the Face ID that we all have on our iPhones, not just ChatGPT. It goes beyond that, but it's what it impacts us the most when we talk about regulations and what we think about we need to regulate, or if we're regulating before time or ahead of time. We think about what all that it's needed and why this has been such a big thing in the last few years. I believe that my partner that it's there, he's gonna talk about this a little bit. I don't want to talk too much about this, but what you see here is not just apps or businesses like OpenAI or Anthropic or Mistral or Microsoft. But we need a series of factors like computer ability, like data, the quantity of data that is available to be able to train systems that are based in data. Machine learning, automatic learning is based on in rules. We see less now. So the question is to regulate and how to regulate. It's very important to differentiate. If we think about any other technology like electrical engines, if we regulate technology directly, we can have problems with innovation and competition on how that's gonna develop. Well, we need to regulate many times because there are some values that we live by as a society, especially those who are in democratic societies that we have values and rights. We have to think, how is this going to be regulated and what do we need to regulate is the apps of those, how we apply those technologies. Like electric engine is needed for electric vehicles, so these are important for environmental purposes, but it's also important. So with the guide, it's more or less the same. After saying this, and I'm gonna end with the presentation, the risk is if we go before time or if we try to regulate technology just as technology, we can we can overload, we can compromise innovation in the sector. So we need to pay attention in what we should do or what we're trying to do. Internationally and also in Europe, that's the approach to regulate how technology is applied. So we're gonna see it now, and we're gonna see the act, the EVA Act, and if it's good or not. I'm following up this line with Begonia. If you just came, she is a researcher, and her focus is in the interdiscipline of these matters and how they can affect innovation. Following up this guideline, Ricardo Fischer is here. Many know you, and he directs the brand and patents of Brand Fox, and he knows a lot about regulations. When we talk about regulations, what are we talking about in artificial intelligence in the United States? How do you see it now? Well, before that, thank you for being here. It's been so early on a Tuesday at 9 a.m., so I really appreciate it. Look, I think that the other day we were discussing about it. There are some approaches nowadays, and I'm not in the position of saying which one is right or which one is wrong. In the United States, for example, we have been able to agree on like what the definition, a technical definition of artificial intelligence is, that the Congress, not the government. So if we don't agree on definitions of what we're regulating, then it's not regulated, but it's not clear. So do you agree with Begonia that it looks like there's an idea that it's approximation of regulation by application? How would this look? What will this look like? I wanted to go deeper in what Begonia said. I believe that generally the impulse, many times, because we talk about it, we talk about artificial intelligence in the public, that it can be harmful, it can change humans' lives. Politically, the urge is to regulate. There is pressure by the public in the political field, but Begonia said something that, for example, in the United States is very important. It's the balance between regulating and protecting innovation, especially with artificial intelligence. Not only it doesn't only have a great economical impact, but also national security. You need to be careful what you're regulating and which sector you're regulating it. The United States, the feeling is more like you cannot regulate everyone equally. It depends on the sector that you're in. If it's more critical or less critical, it is possible that some federal agencies regulate it and the approach is different. So on that, it's not like there are no regulations, but there are components, and if you set them apart, they are regulated. Yeah, this is very interesting. So this approximation that you're doing by industry and components, talking about what Begonia was saying, you see that there are many norms that are regulating indirectly, whether through application or industry. What would you think a proper approach would be? Do we need to wait? Do we need to put together all these regulations? How do you see it? This that I'm being told, these different points of view. This is very interesting. And Ricardo, you have background in international law and also in this area. And also, Europe has also been pro regulation. So, what are the different points of view, European points of view, and North American? Okay. So I've seen in the rules of artificial intelligence that are going to be published in the official newspaper. And we've been negotiating in the past 3 years, but also norms before, like the data protection rules that are not born again as something that is a novelty, but it's been there since 1995. It's that the focus is based on risk and the risk for the usage of technology in some sectors. Maybe one of the main differences that I see compared to something else is that the civil system, is that it tries to look for a rule that is horizontal and applicable across the world, and center in some minimal requirements for everyone. So these are the game rules, and then we can play and we can specify it in one sector or another. So when we're talking about artificial intelligence following this system based in risk, and then we need to see if when we use this approximation, who are the people who are responsible, who is the norm or regulator, and who is responsible for these systems, because there are complications here. If we talk about those who produce or that place a system and algorithms and then use it for an app, or then the user uses it to do something that it wasn't even thought of, then things start changing. So the intention here from Europe has always been that to place very minimal norms. The approach will be horizontal, and then in more specific sector, we need to develop it more or less. But checking on the specifications, that's the main differences to a system that it's more based in a common law. So I leave Ricardo with that. I think that fundamentally, and remember, even though it looks like Europe and the United States, the approach is different, I think the baseline is not that far apart. The United States also believes in the risk-based approach, and there are commissions in both countries that are working together, trying to have certain standards, because it doesn't work if the North American standard is completely different, and then in a way this is gonna impact the commercial part in the future for European companies that want to operate in the States and the other way around. So there needs to be, and we're trying to create standards. I believe that mostly is how to get to the conclusion. In the specific case on United States, in the we have the executive, the president, that can give executive actions for federal agencies, FCC, and like that they can develop guidelines of applicability and best practices in AI. And then you have the federal Congress, the US Senate, the US Congress, that obviously can discuss laws in a federal way that apply in the entire country. In data privacy in the United States, there is no federal law, but each state have their state laws that apply, but not in a federal way, but a state way. And of course, you have the part of case law and courts. Megan, in her presentation yesterday, I was very curious that she talked about cases of court all courts are now, and that started before we started talking about AA. But she said, well, this is applicable with AI. I think the United States, it's a little bit, eventually it's gonna get it right, but don't rush into regulating something that it's very dynamic and that we still don't understand fully. So this that you're saying is making me have some questions. Europe, it's more concentrated in norms, and the United States, it's more permanent permanency on the federal law and the federal rights, and to recognize the federal rights. Yeah, we try for all the matters. There is federal law if it's too needed, like property, like intellectual property. Yes, there are federal laws, but parallel we have a state law. So the federal norm is the exception within the system. However, in Europe, this is not this way, right, Begonia? There is a system of more concentration, or how is that approximation? It's more harmonized. The European system is not federal. There are competences that the members of the union, since they're members through primary right, they delegate, and there are some matters since the final object is to have a unified market where the principles and the freedoms of the treaty can emerge. Evidently, we have some matters that are more harmonized, and there are others that are more in the hands of each state that it's a member, like civil rights, contractual rights in the European Union. It's not harmonized that way. There are no rules on contractual rights. There are rules and regulations on some aspects in some sectors. For example, in syntech or in other sectors like automobiles or medical devices, but it's very exceptional if you compare it with what we have in the United States or what we can see in many other continents. So in that way, when the Commission makes a proposal of a regulation, they want to respect those minimal standards as non-negotiables. It's basically is the two tools that they use the most, more than diffusions, or it's just the board and the rules, and then it has to be negotiated. The board, the 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 guidelines have to be implemented, and then each state that it's a member of the European Union needs to see how to apply it. And there is flexibility, but with rules, with the regulations, then there is no flexibility. So all of the space of the unique market there needs to be more regulated, and that's the standard. So I remember that when we were talking about this, there was a doubt on where this started, this proximity to regulations. The story of each territory of the story of North America is a little bit different than the European story. So this is more in origins that have to do with the Second World War. Like, can you give us some context of the European fears that lead them or lead regulation of this matter? Maybe on like this moment, the question in that sense, we need to be careful because I need the norms of artificial intelligence is not based on fear. I think what it tries to do is to be pioneer, the same way as they do approximation in the United Nations. It's different to base a decision on fear or base it on a very organized process and say, well, there is a series of fundamental rights and values that I want to protect, and I want that any business or any participant in the market wants to establish themselves or wants to use the European market or wants to innovate and produce and make product and sell, they have to respect these values. I think this is the approach. It is true that when we talk about privacy and that data protection, then there are traditions in each country, because the conversation when we're talking about this, about fears, it was more aligned to that. The standards that we have culturally, or the cultural heritage, from the need of the data, personal data, have to be protected, and that they cannot just be out there freely, has a lot to do to what it happened during the Nazis, and in Italy with the fascists, and in Spain with dictatorship. There were data that were used by the governments, data of individuals, to decide, well, extermination, trying to have to make genocide like it happened with the Jews. Same way when we talk about deep fakes, when we talk about dangers of misinformation, fake news, as we've seen before, what happened during elections in the United Kingdom a few years ago. Of course, all of that still is still there. So when you come close to, well, what are the potential risks? Taking into account that one of the fundamental values is the protection to life, protection to free market, but also the values of the democratic values. It is normal, or to me as European, it's normal that that wants to be protected. But I don't think it's based on fear. I think it's based on, well, we've made it all the way here after Second World War. We have established this. We want this to work. We want the European Union community work and to keep these values, and this is the way. Ricardo, about this, what do you see? The regulation in the United States has an approximation a little bit, an approach a little bit different. Why is it different? Well, I believe that there are basic principles that I see in the development of politics when it comes to policies with AI, and it's the protection of human rights, data privacy, and promotion of democracy. I think you can simplify it in those two aspects. And then there are lots of applications in human rights, not only the right of privacy, but on the intended biases. When it comes to artificial intelligence, it will be extremely important that you can have an unintended bias. And an employment process is taken by it's being led by artificial intelligence, and what if the data set of is has bias, or the algorithm has a bias? So it's a great worry, and New York is regulating the usage of artificial intelligence for hiring processes. So again, when we talk about conceptually, Europe and the United States are very aligned. We have democratic principles and human rights that are similar. How did we get there? It's different. Definitely, civil rights versus common law is different, but in the end, we're gonna get to something similar. When we talk about GDPR, with the Brussels effect, is also that, for example, in data privacy, California is something close to GDPR, and California is a little bit more progressive. But eventually, I think we're gonna get to same conclusions. And this situation, I'm gonna go out because how the situation we've seen, okay, the West has these values on artificial intelligence. There are situations that have been identified that are different in the East, regulations or lack of regulations or the usage that go against these principles. So what is the trend on that matter? Well, for example, what Ricardo was saying, to make automatic decisions in the European Union in the GDPR, when it was approved in 2018, the 22nd article was regulating that. And it's very important to see how this article is gonna work together with the um, regulations. And yes, it is true that there are other traditions and there are other countries that have other values. How is this gonna be developing international, and the role of G20 or the G7, the role of the United Nations, that it's right now a little bit on artificial intelligence, and it's doing the work of this international um, entities. It's more important than ever, because it's true, if not all, almost all of us who are here in this sector of digital sector and artificial intelligence, we know this, the score system in China, and like Ricardo was saying, we were is in New York making decisions based on something automatic, automaticide. All the discussion that has happened in Europe negotiating the AI Act, who can and who can't, and how the biometric systems, when they are automized, what's the risk? So I believe that in the end, despite the global intention, and that's why there's this thing, the Brussels effect or the European effect, not even more so about exporting, but the normative standards. The European market is very interesting, but anyone who wants to operate here or wants to use data of European citizens, these are the minimal requirements that they had to meet. So that's the values as society, human rights, that have this very important role. So in that matter, Ricardo, please tell me if you agree or not, but I think in that matter, Europe and the United States are in the same boat. And to put aside the same way as with commerce, it really it can be complex, but the same way as there are commercial decisions like, oh, there are too many risks on this business for these countries, and there are measurements, legal measurements that can be done. That's one of the tools. The systems, the international systems, are already taking this into consideration, and how you use them is where they can take us to.
100% es más.
I agree. Even more, I think that this gap is going to broader, and I don't want to make this a political forum. No, no, but there's a personal title. You're going to see a bigger gap between the countries for the rights of their citizens, civil rights, fundamental rights. Countries that are going to use AI as another, with other purposes, and even more. We are not talking about a case of AI, but let's put a name on it. What is going on with TikTok in the United States? What the biggest concern about TikTok in the United States? In the States, there are big concern of what they're going to do when at the end of the day the China government is collecting data of the users, and they can use that against the national security of the country because they're having access to their lives. So what is happening, they're making norms, or whether they close TikTok or it has to be owned by a non-Chinese company. And I think that we are going to see that a part of that in the United States. There are not regulations that will prohibit this investment in things of AI on China, or export controls if you want to export some type of hardware or software out of the United States. I think that it's very sad that AI is going to accelerate those gaps that happen, that already exist between countries. They are going to be accelerated much more in military system, trade systems, and those gaps are going to start to open up. And the European Union, United States, they're going to be aligned, and these gaps are going to be bigger and bigger. and going deeper in the regulations and norms. It's very important and interesting. United States has expo control for many years now, and with the investment of other countries, I think that's also there. Yeah, that doesn't apply to it. It's there, but doesn't apply. It's not defined as a gender inter AI. They have expo controls. That's there's. It's just there. Security for the nation, or Begonia. Is there something similar in Europe of what United States has in the matters of security and AI that can apply to this kind of technology? Yes, sure. Now there has this package of governance, and this comes from before the agreements that are of trade politics and agreements of the European Union, but not only this, but on an international level, the World Trade Organization. These mechanisms have existed, and there are many examples. For example, what is going on in United States and China with the cars in United States and European Union of electric cars that come from China. We can extrapolate this to other sectors in not United States or United Nations regulate this per se, but to regulate these applications means that the same, there are some components that are going to stack together, and there are some sectors that are strategic, where you can have more control. We can see that in the area of quantification of the United States and European Union, where there are much more agreements, and evidently that's there, but is that the kind of model that we want at the end of the day? Just to use these measurements, we have these measurements, and to use them it's all right, but to base all of the governance of these new types of technology, these applications of these technologies, it's what really, I think, where we need a different answer. Because at the end, what we want is that the market provides that the participants on the market see that there's no competition, because that's always going to be better for all the consumers, that's all of us, but that it needs to have a respect for human rights. All right. All right, then if you want, we can go deeper. If you want, Ricky, to that you and Begoña could tell us about the norm. It's a little bit bigger. It has a lot of chapters and subchapters, but if you read the topic, there's a concept that you mentioned that is regulation. How do you want to talk about how this is seen in the European nation and what is going on with the regulation? Yes, I think that for that it's better if I share my screen. See, very briefly, what we have in the European nation and what we have worked on, as I was mentioning before, is to present these minimal standards that will favor the internal market. And following it, we have the philosophy of new legislative framework, that it's a framework, it's an approach that was approved at the end of the 80s when the standards started to be regulated for technology. And when what this is trying to do is to favor this new legislative framework is to favor that the standards technological standards do not come from the legislators' data because there are no techniques or they don't know about technology, they don't know what's better for it, but that it comes from the industry, from the ones that make the technology and that help that make these standards that they are based on these minimal judicial standards. So this relationship between the legislative here and the technology here, it's fundamental. What other thing does it has? It has a horizontal approach. There are excluded what Ricardo was mentioning, the national security, military, and defense. But then after, if there is an approach to specific sectors because of the risk, they can be included, but it's a norm as many that are approved in the European Union, then after they have to be merged with the rest of norms that are already approved and exist in the European Union and that can be applied like consumer protection, databases, the DSA, DMA, and all of the norms, previous previous norms. Not only the AI is going to be applied to artificial intelligence. And why is this important? Because to the effect of application of different sectors, it's that's what the norm establishes is that we have the Brussels effect, is that it's not only going to affect someone that is in the European Union, but anyone that wants to operate there, that wants to deploy their products or services in an European market. So this has an expansive effect on what is their risk-based approach. There it's like light, street light. You can see that there are some safe, there are minimum risk, so it's not applied. Some that are have some responsibility and transparency. It's not applied to everything, but they have some obligation that are high risk and the unacceptable. The high risk are the ones that are allowed but have to play with the rules of the game. There are some measurements for them, and the unacceptable that are just prohibited. We're talking about automatized decisions in the algorithms, for example. One of the things that I think it's very interesting to talk about is it has been said that if this act has been approved before the end of 2022, like their ChatGPT wouldn't be included on it because there is no a definition of, and we purists we have this obsession to define everything, and not even the scientists can define what AI is. So this wouldn't have been included. Maybe it would have been included, maybe no, but the reality is that at the end, these models that according to the norm are general purpose AI models, they're very similar what to what has been defined as an international model. Yep, as you can see in the left downside, there is the definition in the center and our research center and the definition that they gave a couple of years ago to these models that in at the end of the 21 was published about these models, and they have only one model. And when you put a lot of data on it, then after you have to make some inferences of these models and how can you apply them in different areas. By that time, it was a big step in the technological field, but you cannot forget about the investment and how much it cost. So
O sea, esto no va a entrar en vigor ya, o sea, es progresivo, entonces necesitará.
can you hear me?
Teléfono, la ven, ¿no? Estos son mis slides.
Can you see my phone? There are the slides there. While we wait, Begoña, is she there? She's back. Begoña, can you hear me? Okay, keep going. We lost connection. We just lost you for a couple of minutes. I don't know where did you lost me when you introduced yourself. No, in we were here in the risk analysis. We were in the last one. Yeah, you were talking about how the new general purpose AI models, if the foundation maybe have excluded. You have already talked about that. And a little bit, I think the question was, what is this about the conceptualization of risk, or what are the risks that you can take as a criteria? I think, and there you go with your arrows or something that we were able to see. Yeah, the arrows are of the implementation. So it's step by step. So this is gradual. It's not all going to get all at once in service. But I think that something that I don't know if you heard it or not, but one of the aspects that is very important here among the norm is that we need codes of conduct and certifications, and most of all, the dialogue between the stakeholders, all the participants, and the legislator. This means that even though the norm is going to be published in the next norms and it's going to be established 20 days later, there are some steps that need to be taken. So little by little, we can take the rhythm of this technological advance, and this is not written in stone. So it's really, really open to change in the future. So this fear that it was that the general purpose AI models can be changed on the future. It's not established and set. So in Europe, these norms take time and a process. And in this case, it's important to remember that because of the effects of this norm, based on the risk, which are allowed or not, which are excluded or have these transparency obligations, the ones that are high risk and have more requirements, and the ones that are prohibited because of the risk that they mean, on all the decisions that are automatized, for example, based on personal data. Those are systems that are prohibited, and the idea of all of that is that this norm is alive, and we were talking about sandboxes and spaces where you were allowed to experiment with the evolution of this. And Spain is one of the countries that is going to start with these sandboxes to see how they work, how the market is affected by it, and the negotiation and the dialogue on these organizations that are focused on the stabilization of this. I think that's where I was, and the norm in the European Union. And I hope that you were able to follow me. No, it was great. Ricardo, we are going to see what the same, but from the perspective of the United States. And we're talking about this we will talk about this at the end. All the implementation. I think we need the other one. I'm gonna try to I'm gonna try to talk quickly so we can have a discussion time. I'm not very graphic, so it's a lot of text. So basically, as I was mentioning before, it exists several security actions that are very important, but the security actions just apply to the agencies, federal, not to companies, and they look that the companies are coordinated for AI. So the most important agencies right now that have their lines, the the FCC and the FTC. On the side of FTC, they can regulate chatbots, both clothes, these sections for sale, dark, looking for dark patterns, and that use some because that uses information of the consumers. And the first part or executive order that we call a blueprint for an AI bill. I don't want to repeat all the principles, but you can see that it includes what is data privacy and the algorithm discrimination protections as the part of the principles that are fundamental that we need to take into account to build this in an organization. And also in 2023, based on that Bill of Rights that was promoted, it includes security standards, privacy, always including equity and civil rights. But you can see that it always balances with promoting innovation and competition, trying that United States keep its niche on the global markets. So I think that if in your countries there is a conversation for AI, you need to create a regulatory sector, but always making sure that your country stays in the competition. And right now, there are some proposals like Schumer among the congressmen, and we still have pending. I don't think that there is something going to happen on that front, but In November, we're going to see. It depends on what happens. If the road will change, if Republicans, we can wait that there's some regulation, but less regulation. On the state, on the states, we can also see that they are asking for regulation that are risk-based approach because we don't have a regulation for AI. I don't think that there is anything in the future. I'm going to just go very fast on this slide. Everything that has been discussed, these are so of the points, basic points, but you can see among them that we have national security and international competition to promote transparency of what it is, the programs of AI, and you can see and establish a licensing regime, and that goes in hand by the pure response. And if there is more protection on the AI, you need to obtain a license for a state committee on an indirect way. And when we're talking about AI privacy, I have talked about the United States case that has a law that has regulate automatized programs of higher process. And where are we now? So obviously we have these agencies of government, executive government, that can protect and can look for deception, unfairness. Uh, this applies to everything that is deceptive conducts, if they have advertising privacy. What we were talking about, the sectors, if the credit sector that also exists, there are some guidelines in the employment sector and the body of civil rights. And on the business, I don't want to talk a lot about IP because they talked a lot about it yesterday, but as they have mentioned, on probability and work that they have used AI, that's an example of how each agency can look and regulate without an existing law, like a copyright law. But now we have this new item that's a guideline that we can give to consumers that explains very well what you can register or what you cannot register with AI assistance. Looking ahead, I don't think that we have a comprehensive legislature. I think that we are going to have targeted decisions in courts or in agencies or in a state level that look for regulate situations that are very specific without trying to regulate all of it. And this is an example that I have brought of OpenAI that has already been under research for the use of information in their inputs and in training data sets. This is something that I've been asked if it's regulated in the United States, and I'm going to say yes and no. It depends. No in a comprehensive level, but yes by several tools and assistance and federal agencies, several legislations in different states. And I like the concept that Begoña mentioned, that this is one of the motors of self-regulation. The industry needs to self-regulate, or there are sandboxes. Sandboxes that do not stop, but while you are creating this in in coordination with other agencies, it could be on a safe space. And while we get Begonia back here, as we have little time, I would like to answer some questions if there are, and I would like to start with one from professionals of the law. What is the approximation that we should have as lawyers to these topics on our clients? And I saw the term compliance, if that should be our first approach to clients, if they are or not in compliance with the regulations, or how do you think that in the exercise of our profession, how we should approach this? Begonia, you, well, in the case of the norm, we have seen that all the law firms have been following the development of the norm very detailed, and that since the final text was approved May 18 and it was published, they have been launching webinars informing their clients, because if the systems, if you get into what is service provider, deployer, etc., among these, the norm includes, your norm could be within the high risk or the transparency ones, and you need to take some specific measures that are in this norm. And I think that they are already informing on that. And also I think that to work with an understanding of, because we can try to understand, but I think this is something that takes time, and most of the law firms that work in the digital sector, it's not something new when we talk about AI, and I think that is the most immediate approach and the more sensible one. Because in the United States, I think that they will take into account how the programs are working there, but I don't think that it's going to be too different. I'm gonna tell you about our experience as a law firm. At the moment, we had a group or a division of blockchain and metaverse, and now is blockchain, metaverse, and AI. We need to adapt to the times, and there's much more activity today in the part of AI, and there's a lot of activity in blockchain, in the use of tokens, utilitarian tokens, and we have seen that in some capacity what are the consults on the branch of AI have grown, and we think we see this in different sectors, export controls. Now you have to go this to our international trade. It could be data use. Okay, you need to go with our experts on that, or intellectual property, that we have these clients that said, look, we create this image, these slogans, this campaign using AI. What are the limits? What we can do, what we cannot, what we can choose, what we can protect. And on the United States, in the level of governance, companies use a lot of what is pretensions. How much time do you need to save the documents on based on your legal responsibilities? And they have started asking, how long do we have to keep this prompt that we use in the system to create these brands? So definitely, yes, we have learning a lot and asking a lot of questions. And I think that first we need to understand technology, We really need to understand technology. If we don't understand, we are not going to understand the questions. And second, we need to understand it very well. And Tony was mentioning this yesterday for ourselves as a firm. If they want to adopt or not, that's not the question because the competition is going to adopt it. And for me, the best is not the one that use it or not, is the one that use it the best because these AI models have a structure that is completely different of what we know of a searcher. You can use an AI as a searcher on the web and know how to push and find what you want because it helps you find what you want. Very clear. Thank you. I don't know if there's a question among the audience.
Thank you very much for this presentation. I have a question, and it's do you talk about the state of things and many times to translate things that already exist through infractions in AI, but when we talk about enforceability of rules, I'm talking nowadays when we do something about an infraction on Instagram or something like that, there are 10 new accounts. So how to apply those regulations to protect like before vulnerations on AI rights. To synthesize, the question is the situation that is generated with using chat to using artificial intelligence with the opening of infractions. So let me talk a little. I think I understood the question. Basically, yes, with the usage of artificial intelligence, i- infractions, it will be a facilitator to multiply infractions. Not necessarily the infractions, because you were talking about regulation of artificial intelligence in many aspects. So it's vulnerating privacy, civil rights, workforce. How do you see that beyond those regulations, it can be applied in an effective way and have effective sanctions? No, of course. Remember that we have different infractions. If we're talking about the workforce, if we're talking about intellectual property, about these violations, it's different. When you're talking about AI, you are talking about regulatory aspect, but it's very extensive. It's a good question, but we didn't focus today on intellectual property. So when these violations started on the internet and in the United States, the MCA, there are new mechanisms that were created. So in a way, can make it faster to get the notice and takedowns. So in the future, the regulations and new situations that we can have in artificial intelligence in a measure that to very specific things, we're going to need new tools. Well, there are going to be regulations on those new tools without saying that the laws need to be changed. Yeah, and I think that there are many norms that are gonna be applicable because this goes through a lot. So we know the path that we need to walk on, but we need to understand how artificial intelligence works so we can articulate our knowledge. And it's a good point because let's say we're using technology and algorithm. What do we think about in the future in the workforce? And you as a lawyer in intellectual property, well, you have the technology. Explain to me what this is what the algorithm is. So whoever understands the technology, even if you are in an intellectual property environment, you're going to be in a privileged position to be able to extend to other areas. Sorry, Begonia, I didn't let you speak. No, in a way to understand the technology, I totally agree with that. When it comes to enforceability, I think that's the question, the key question. But you also answered that question. I don't want to repeat myself. In the European, when we talk about Europe, the regulations for artificial intelligence, there are some very specific systems on viability, manage of workforce, biometrics settings, and there are requirements that are higher than in other sectors. But that doesn't mean that if there is a problem like Claudia, I think, what's her name? If we see that there is an account on Instagram when their artificial intelligence systems, there are going to be 10 or more accounts. Well, in Europe, it was a little bit more the responsibility of providers with the law of digital rights, but it has nothing to do with the artificial intelligence regulations. But it's all the laws together, and as a lawyer, you will have to work on this. So on the digital world, and I don't work as a lawyer, but I see it as a challenge for all my colleagues because I'm still a lawyer, but I'm not working as a lawyer. But this field is so wide, so great, and so technical. And it's a more technical and systematic vision because you don't only need to know about intellectual property only, but you also need to know about responsibility, technology, contractual rights, what happens with data protection. So that's the challenge. When we talk about specialization, when we talk about digital objectives, it's a little bit more complex. What do I need to cover with the people that were working on workforce or in the medical field? This is increasing for everyone. So it's fundamental to understand the technology. Well, thank you. We are out of time, but I want to thank you, Begonia, for illustrating about this topic that there's so much to talk about and we need to go deeper. And thank you, Ricky, for sharing your knowledge, both of you, and the perspective on how to approach, how to get out of the hyper specialization, but we need to be more general now. This is very interesting. I thank you very much. Thank you, everyone. Give them a big round of applause.